General for the Boards and Open Government Division, which includes the Open Meeting Law Enforcement Unit, the Nevada Attorney General's Office. So I'm going to be giving a general overview of Nevada's open meeting law with a little bit of a focus for, I'll try and get a lot in here for both attorneys representing boards and commissions, as well as for members, as I know we have a lot of members in here as training as well. So I'm going to cover generally what the open meeting law is, when it applies, how to comply with it, and how our office handles complaints, or what to do if the OML has been violated and there hasn't been a complaint, as well as some updates from the 2025 legislative session. So the OML is housed in NRS Chapter 241. It requires that public bodies take their actions openly and that their deliberations be conducted openly. This is the stated intent by the legislature and guides the interpretation of the law by both the courts and the Attorney General's office. So in determining when the OML applies, the first step is, are you a public body? Is the group that you're a member of or that you're representing a public body under the law? Because it doesn't apply to every gathering of government individuals. There's a detailed definition of the term public body contained in the OML, but generally, public bodies are bodies created by statute, executive order, or by action of another public body. This includes subcommittees and can even include the governing boards of some corporations if they meet the creation requirements contained in the statute. So these are government bodies. To the extent you're here because of a Title 54 board or another board that you're a member of, you probably know you're already a public body. But there may be other local government functions that you participate in, as well as it's important to know that subcommittees, even if not very specifically created as a subcommittee, can be a public body under the law. And when I say that, not specifically created, we've had opinions, situations in our office where I'll give the example. This was a rural town board that two members of the board started discussing outside of meetings fencing regulation. And they would report back to the meetings regarding that fencing regulation. And they started doing this on a regular basis. And the town board started deferring to them on decisions regarding the fencing regulation and even started calling them the fencing committee. However, this town board had never taken an action to designate them as the fencing committee or create them as such. However, even they were acting as one and being treated as one. And at that point, we said, yes, they were a subcommittee, which means they need to separately comply with the OML. If you're ever unsure if a group you're participating in is a public body, consult with your legal counsel. For all these state entities, that would be your DAG. Or there are other outside as well. If you're representing a public body, focus on how the body was created, what it's tasked with doing, and who chooses its members. There are exceptions to the general mandate, a few of which I'll discuss, but the Nevada Supreme Court has stated that the spirit and policy behind the OML favors open meetings, and any exceptions thereto should be strictly construed. So if you're unsure whether a group, a subgroup, or some gathering of public body members counts as a subcommittee, there's a good chance it probably does. But I will note the next step is, if you know you're a public body, is it a meeting? And so the OML only applies to meetings of public bodies, which means a quorum together with deliberation or action. So a quorum in Nevada, the general definition of a quorum in the law is a simple majority of members of the body. There are some bodies that have specific legal authority, a statute perhaps saying this is what a quorum is. So if you have a more specific statute or requirement, that is your quorum standard. But if the the legal authority creating you is silent, then a quorum is a simple majority. Deliberation means collectively to examine, weigh, and reflect upon the reasons for or against an action. An action means a majority vote of the members present or a majority consensus. For elected bodies, action requires a majority of all members, not just those present. For appointed bodies, action requires a majority consensus of just the members present. So it's important to know which rule applies to you with respect to action. The exception here was mentioned in the last presentation. That is with respect to abstentions under the ethics law. And in those situations, you count your quorum and the number required for action as if the member abstaining was not a member of the body. So it basically reduces everything by one. And again, that's only if the abstention is under the ethics law. You'll hear a little bit about disqualifications in an administrative rule procedures presentation later, but if you are disqualified from participating because, for example, you participated in the investigation of a contested case and that is now coming forward for discipline, and maybe your board member acting as a witness, which is not that uncommon to happen, you don't get the benefit of that quorum reduction. You still are disqualified from participating for due process purposes, but they need a quorum, assuming you were effectively a no vote, and they need a quorum without considering you removed. And that's one thing I did want to mention. If you have a number of people disqualified, though, there are provisions that will allow you to get substitute members from the governor's office. That can be beneficial if you are worried about having enough people for quorum and action. So as I mentioned, you need deliberation or action. A gathering of a quorum at a social function or a professional function is not a meeting so long as there's no deliberation or action. So you really need to pay attention to what you're discussing. The general advice I often give to bodies I represent is if you're at a function that isn't a board meeting, it isn't noticed, and there may be a quorum of you there, don't talk shop. Just don't talk about board business and you're probably safe. The exception here is an exception to the definition of a meeting. That's the attorney-client exception. A conference regarding legal advice can include deliberation so long as the deliberation is limited to the legal advice. It's a full exception to the definition of a meeting, meaning it does not need to be noticed. It does not need to be recorded. There don't need to be minutes. That differs from closed sessions, which I'll discuss a little bit later. Some people call them closed sessions. There's no problem with agendizing it and then recessing into an attorney-client conference and coming back. But it is a true exception. So if you have an impromptu emergency phone call with a quorum and their attorney just to receive legal advice, that is permitted. An update from the 2025 session, and again, I'll summarize these later, but the attorney-client session can now include legal advice that is not specific to pending or existing litigation. However, it's important to note that the deliberation needs to be limited to that legal advice, and any action needs to still occur during a public meeting. And serial communications and electronic communication are big areas where public body members can mistakenly run into an OML problem. For electronic communication, email, this is the biggest area that there's a problem, is if an email is sent to all members of the body and then members start replying all with opinions, anything that gets into that collective exchange of facts, preliminary to an ultimate decision, that's deliberation via email. So if a quorum's receiving it, you're conducting a meeting via email that wasn't noticed, that wasn't open to the public, and that would be a violation. That's why you'll often see staff emailing you. This is a recommendation from our office frequently, that if staff is going to send out an email to all members, they BCC everybody, so just nobody can click reply all. Little things like that can make a big difference. Serial communications is an area where we get complaints from time to time, and it's also considered a walking quorum. That's an area where more mistakes occur. A constructive quorum can exist even if you don't have a quorum of members together at one time. I often give the example with a 7-member body. 3 members meet in the hall after a meeting to discuss an issue that was brought up during public comment maybe, or that was discussed at the meeting. And they talk, express their opinions. They can even deliberate. There are only 3 members. There's no violation there. But a week later, one of those 3 members, A, B, and C, right, met in the hall. Member D and member A run into each other at a coffee shop. And during their conversation, some board business is brought up, and member A relays the content of the conversation and the opinions relayed at that earlier gathering of members A, B, and C. Well, now you have a collective exchange of facts between 4 members, which is a quorum. And that would be serial communications in violation of the law. So if you participate in a less than quorum discussion and you say, okay, I'm less than a quorum here, I feel good, we're fine, we had this discussion. Each of those members who participated in that needs to keep in mind that they can't go have another conversation. Situations where some bodies I have seen do this permissibly, I guess I say sort of serial communication, less than quorum groups that is specifically permitted in case law would be you have a city manager who meets with each city council member prior to meetings to go over the agenda, discuss any issues they may have, any questions they have, what information they want. So long as that city manager does not relay any information that was said, basically cross-communicate between their several meetings, then you're fine. The city manager themselves isn't a member, and as long as they don't act as a go-between, those meetings would be completely permissible. I've also seen where a city council and maybe planning commission have back-to-back meetings of less than a quorum, where they maybe get presentations from a developer or other things and get to have plenty of time to ask their questions, get everything fleshed out. However, there need to be very, very strict instructions given to all members that participate in any of those, usually 3 then, because then each one can have less than a quorum and you get all members, that no communication crosses between. You do not talk about these issues with anybody that was not in your less than quorum group. So again, as long as you have those very strict instructions, if we get a complaint on it and there is no evidence of any cross communication, there is specific Nevada Supreme Court case law permitting the practice. Again, it is those practices need to be done with caution, with very clear legal advice to all of your members, such that they don't mistakenly fall into a walking quorum. But we frequently get complaints too. So if you want to avoid it, just not to have the complaint, not a bad idea either. I'll pause for questions before moving on to agenda requirements and meeting requirements. Any in Vegas? Do we have any questions in Carson? I don't see any. Okay, I'll move on. So compliance with the OML. The first and arguably most important step is notice of the meeting. That would be your agenda. It needs to include the time, place, and location of the meeting. If the meeting is entirely virtual, which is permitted in certain circumstances, then information on how to access the remote technology system hosting the meeting, whether it be Zoom or some other software or even a telephone call, needs to be listed on the agenda, including a telephone number for public comment. So even if you're conducting the meeting exclusively via Zoom, there needs to be an option for public to call in who doesn't have internet and listen over the telephone and make public comment over the telephone. That's not required if you, which is a slight change from 2025, but if you have a physical location where public is permitted to attend, you need at least one within the state of Nevada. The agenda must also include the name, contact, and business address for a person from whom the public may request supporting material, plus a location that can be that business address. There is no current requirement that supporting material be posted to the internet. Unless there is entirely virtual meetings, you do need to post it to the internet. But if the meeting has a physical location component, you're following the physical location requirements, you do not have to post supporting material to the internet. However, I highly recommend it. It will reduce staff time in answering requests for supporting material, reduce costs, and increases public access. So I'm always a big fan. There need to be clear and complete statements of topics scheduled to be considered on the agenda. A higher degree of specificity is required for agenda items of substantial public interest in order to meet that clear and complete requirement. If you're wondering if something is of substantial public interest, ask, does this generate a lot of press? Does this generate a lot of public comment or attendance from the public? In most circumstances, it's fairly clear whether this is something of significant public interest. Public body members know that this is a more controversial item or whatever it is. At that point, you need higher specificity on the agenda, so it's very clear. It is important to note that, at least for our interpretation by our office, the clear and complete requirement is there to give public notice of what's going to be discussed, so the public can decide if they want to attend. So this does not require every single potential action that could be taken by the public body be listed. But what is going to be discussed and potentially acted upon needs to be in enough detail that public can make an informed decision for themselves, whether they want to attend, whether they want to make public comment, whether they want to be heard on the topic. All action items need to be denoted as for possible action. Those three words are in quote, are in the statute specifically in quotes. So we require that I would put those exact words in there. Most agendas you'll see, they'll just have parentheses by an item that says for possible action. Just because an item is denoted as for possible action does not absolutely require action be taken. But if you do want to act, it needs to be listed as that. Public comment periods and restrictions also need to be listed on the agenda. I'll get into on a later slide the details of when public comment needs to be permitted, but it does need to be clear so public can know. You can always add more public comment during the meeting than what's listed on the agenda, but the minimum needs to be there, and you need to take public comment when it's listed on the agenda. Some more additional requirements and specifics are included in NRS 241.020. The agenda can be a little bit nitpicky, the agenda requirements. We often caution against, this is a point to that clear and complete statement. We often caution against items such as member comments or just reports. These do not violate the OML per se, but because they don't contain detail regarding what's discussed, they really need to remain just a report, a space for comments, an informational item. If the public body starts to discuss topics under one of these general items in more depth, such that they're starting to deliberate, and to usually what I look for if I'm representing a body in a meeting is they're starting to walk to what should we do about this thing? Like an issue is brought up under member comments or under reports, or even under public comment. And they start to, and the body members talk about the issue, talk about what the problems are, and then they start talking about what should we do about this problem? How maybe we can fix it? That's getting into deliberation. And at that point, that's when the chair or the attorney for the body will likely stop them. That's the point where the item needs to be placed on a future agenda with more detail in the agenda item. And then they can go ahead and talk and everything. It's again about that notice to the public. When it comes to agenda posting, there's a number of requirements there. In general, the physical posting requirements are at the office of the public body or the location of the meeting. If the public body maintains a website, you need to post to your website. In addition, you need to post to Nevada's notice website. A note I'll make there is Nevada's notice website does not have the ability to host a document. It links to the public body's website. If the public body does not maintain a website, you still need to register with notice.nv.gov, which is Nevada's notice website. And make sure that you're at least showing up on their calendar, that your meeting is listed. It does mean that you may not have an agenda online if you don't, and this is really targeting the small, sometimes rural local government bodies that don't have the funds to maintain a website. And if that is the case, the OML does not say you can't exist without a website. However, that will bar you from holding a virtual meeting. Because there's an exception added in from 2023 that is if you hold an entirely virtual meeting, the agenda must be online. So if you don't maintain a website, you cannot hold an entirely virtual meeting without finding a way to share another's website or to call it yours and post online. All of the posting needs to occur, and this includes all of that posting as well as mailing to persons who've requested notice of meetings or emailing, depending on how they've made that request. No later than the 9 a.m. of the third working day prior to the meeting. So when there are holidays and weekends, it's important to calculate that out. If you're public body members, the recommendation I often give is talk to your staff, whoever is doing the posting. And if you're wanting to request items, find out when they need information by, because often all of this posting has to be put together at the latest the day before that 9 a.m. deadline so that they can get it sent to the proper places. That online posting sometimes takes a bit because websites overnight will then circulate and do the actual posting. We also get, to let you know how nitpicky people will get about your posting requirements, we have gotten complaints on multiple occasions regarding postmarks for the agendas that are mailed to persons who've requested notice. So as is under the law and how we've interpreted it is if you need to reasonably anticipate that the agenda will be in the possession of the post office by 9 a.m. of the third working day. However, you cannot control when the post office postmarks it. So if it is postmarked in the PM, these days with some of the changes in federal mailing, at times the post office is taking more than 24 hours to postmark items. So that means deposit them in a blue box with a stated pickup time prior to 9 a.m., physically deliver them to the post office in some way, get it into the possession of the post office. But do not put them in your outgoing mailbox at 8:30 a.m. on the day that you have a 9 a.m. deadline, knowing that your mail pickup isn't until the afternoon. Some additional requirements beyond the agenda. Public bodies must make reasonable efforts to assist persons with physical disabilities desiring to attend a meeting. Meetings must be recorded and transcribed, by a court reporter. So a Zoom transcription or some AI transcript, which more and more here, there's nothing wrong with having those created. They can be a great assistance in creating minutes, but they are not a substitute for the audio recording. As the law says, you need an audio recording or transcription by a certified court reporter. There are some additional specific notice requirements for consideration of a person's character or to take administrative action against a person. This is notice to the person you're going to discuss or act against. It's specific to the individual. This additional notice requirement can be as long as 2 weeks, depending on the type of notice chosen. So it's important to plan ahead. When considering a person's character, taking discipline, that's the most common adverse action that's being taken. However, this notice is waivable. So if you have the other party, the party who you're going to be acting on an agreement with your date, You can hear it without the additional notice. I always advise getting that waiver in writing so it can be proved if a complaint is later filed. That's what our office will often look for. Supporting material is required to be available to the public at the time it is provided to members of the public body. So we get a lot of complaints and questions regarding supporting material, especially in today's environment of virtual meetings. Supporting material is defined in the OML. It means material that is being provided to a quorum of the public body and that the members would reasonably rely on to deliberate or take action on a matter contained in a published agenda. So this means a document does not become supporting material until it's been both provided to a quorum of members and the matter it relates to has been included on an agenda. However, if you're sending board books to your body prior to agenda posting, that means you need to have the supporting material available, or for virtual meetings, post it at the time you post your agenda. But if supporting material is delivered to members at a later date, it just needs to be available at that time that it's delivered. A big caution to members of public bodies, if you are going to share any document with your fellow members, make sure that you are including your staff or whoever is responsible for supporting material is also included and knows you shared that, because even if it's not regarding something on an agenda today, at the time that if it relates to something that's posted on a later agenda, within a reasonable enough time frame that members would still be relying on that document, it becomes supporting material later, and that staff member who controls supporting material needs to have it and be aware of it. The example I've given sometimes is an article that's relevant to the body comes out, a member sends it to other members and just says, hey, this is relevant to what we do. Maybe this is something we should talk about at a future meeting. A single one email send out like that isn't deliberation. That's fine to send out. However, if another member then says, yeah, you're right, we should talk about this, and they go request that it get put on an agenda, as soon as that agenda is posted, that article is supporting material. And I will note, just because an item may not be supporting material under the definition, it doesn't mean that it's not a public record that could be requested through the public records process. So just, I guess, keep that in mind, that as public body members, you'll get a training on public records. While OML materials are public records, they have heightened requirements on their availability to the public. Just because something's not required to be available to the public under the OML doesn't mean it's not a public record. With respect to recording meetings, the recording requirement extends to closed sessions. This is separate from those attorney-client sessions, but sessions that are considered closed sessions under the law, such as, and I mentioned a little later, but such as considerations of character, sometimes those can be closed. Those still need to be recorded. Minutes still need to be created, but the recording for those sessions may be subject to some confidentiality requirements. So you need a way to separate that recording from the general recording of the meeting. For minutes, they need to be kept in conformance with NRS 241.035. That includes detail with respect to who was present, the time and date of the meeting, the matters that were discussed, and detail of what was discussed. It does not need to be verbatim, but whatever was acted upon, motions as well as what was approved, needs to be included in the agenda. And a slight note when it comes to approval of minutes, because minutes must be approved by the body within 45 days or at their next meeting, whichever occurs later. We're frequently asked whether a member who was not present at a prior meeting can vote to approve the minutes from that meeting they weren't present at. The answer is yes. Just because a member wasn't present doesn't mean that member cannot vote to make draft minutes the official minutes of the meeting. Where this is important is when you barely have a quorum at the meeting that you were needing to vote to approve minutes, and you need the vote of somebody who wasn't present. Otherwise, you don't have enough votes to approve an item. Because you have deadlines to approve those minutes, the recommendation would be that the member who wasn't present go ahead and vote to approve. Many will then just make statements that they don't have personal knowledge as to the accuracy of the minutes, but they're trusting staff, something along those lines. That's fine. But you're simple. The vote to approve minutes is the vote to say we're going to make this draft the official record of the meeting. Public comment. It's another extremely important aspect of public meetings. There are two options to meet the minimum requirements for public comment. The first would be a general or item at a public comment period that at the beginning of the meeting that is general, as in anything within the regarding items within the jurisdiction and control of the public body, or that first item period can be limited to items on the agenda, and then holding another public comment period that is completely open and general towards the end of the meeting prior to adjournment. The other option is to have public comment on each action item. Instead of that first period, you have them after each action item, after discussion, but before the vote, and then another general period at some point prior to adjournment. The most common public comment format is the two periods, one at the beginning, one at the end. But both options are permissible. It's specifically stated now in the law, that was actually, I think, a 2023 change, but it's always been the interpretation of our office that you can add additional public comment periods if you want that aren't on the agenda. So long as you meet those minimum requirements, there's no rule against taking additional public comment, even if the additional periods aren't agendized. The recommendation I often give to bodies I represent is the 2-period option that's most common, as it's easy to comply with, and it meets those minimum requirements. But then if the chair desires, if there's another topic that's important coming up, or again, those ones of substantial public interest that you maybe have a lot of public who wants to speak on them, if you want to open more public comment periods later, by all means. Our office is usually in favor of more public access, and I would love to see public comment get to say whatever they're there to say. The main qualifier to any public comment period, in addition to creating those additional periods, is any restrictions on public comment must be time, place, and manner restrictions. That means they must be viewpoint neutral. This is the public's opportunity to air grievances. And for the most part, that needs to be allowed. There can be some restrictions with respect to interrupting, with respect to profanity, but you can't say we only want positive comments here. That would be a violation. We've actually had an opinion on that, finding that to be a violation. In addition, public comment restrictions that are enforced in a way that isn't viewpoint neutral, in a viewpoint based way, those would also violate. So even if the general policy is, say, a time limit of 3 minutes per person, but the chair only enforces it on people who are being critical of the body and lets those who are being, giving positive comments and praising the body, those get to run long. That would be a violation because it's not being enforced in a viewpoint neutral way. I will note that the OML does not prevent the removal of any person who willfully disrupts a meeting to the extent that its orderly conduct is made impractical. And I put the quote in there on this slide because I asked chairs to look very closely at this language, as it's an important standard, and I want them to often even state it, that that's why they're removing a person if they request that a person be removed from the meeting or they ask a person to leave the meeting. But it does give some flexibility to a chair when running a meeting. Public meetings are still in public bodies and part of how the government does business. And there is federal case law, especially when you consider public comment areas, because the purpose of public comment and the viewpoint neutrality is protecting free speech. So there is a lot of case law out there to protect a chair's ability to run a meeting and a civil meeting. So if somebody is interrupting the meeting repeatedly, a chair can request that they be removed from the meeting so that they can continue. And I will note a change from 2025. There had been a statute, I think that was a 2023 change, that the language of the bill required a telephone number to be read at the beginning of public comment if there was any virtual component. That was changed in 2025. So a remote public comment option, such as a telephone number, is only required when there's no physical location available to the public. However, the more public comment options that you can offer, again, I like to see public access, whether that be written public comment, offering it via telephone or via Zoom for public members who are unable to attend physically. But if you have a physical location for the meeting, it is no longer absolutely required to include that. So I mentioned closed sessions. They may be held by a public body to consider the character, alleged misconduct, professional competence, or physical or mental health of a person. They can also be held to grade examinations. There are other areas in NRS, and I don't know if I mentioned before, to the same extent that I've talked about the attorney-client exception as being the only exception, that's the only exception contained in NRS 241. But there are many exceptions contained in various other NRS chapters that allow for specific bodies to be exempt from the OML entirely, or they allow for certain topics of discussion to be either held in closed session or be exempt from the OML. An example I'll give is this applies mostly to local governments, but NRS chapter 288, which is the collective bargaining chapter, has an exception that when a local government employer meets with its management representatives, usually regarding labor negotiations, it's completely exempt from any statute requiring the gathering to be public. So there are a handful, or more than a handful, of exceptions that exist out there. If you think your body may have one, consult with your legal counsel. The exception needs to be listed in the legal authority creating the body. And that's the same for closed sessions. You may be able to hold closed session for other reasons contained in other statutes, but in the OML, the permissions are for the discussion of character, physical or mental health, or to grade examinations. Now, the exception to that closed session provision is appointment of a member to a public body, or to consider the chief officer of the body or agency or similar position. That cannot be done in closed session. And any action regarding something that's discussed in closed session, the action still has to occur, because the definition of action in the law talks about it occurring during a public meeting. So you can go into closed session to discuss the details of somebody's, sometimes that's performance evaluations of employees. That's fine. Any action needs to occur during the meeting. The big area where the exception applies to, for at least most Title 54 boards, is an executive director or equivalent position of the board is that chief officer, and their performance reviews need to be conducted in public session, and as well as any action. For virtual meetings, members of public bodies may attend virtually. This is for not entirely virtual meetings, which, as I discussed, there needs to be public access in virtual ways. Where you have a physical location for the public to attend and participate, members of the body may still attend virtually. However, I want to emphasize in that the public must be able to hear and observe to the same level as the members, whether or not there's a physical location available to the public. So if you have members of the public body attending virtually, they're on Zoom, but you have a physical location where maybe a couple members are and you have some staff, there needs to be a screen available that shows the same thing that the multiple members who are online are able to see. While I haven't actually seen this occur, but coming out of COVID, there were thoughts of this where you might have the public body all in a room videoed to another room where you have public available. There's problems there because if the public body members can see each other beyond what's on camera, there's communication that could occur, silent communication that the public doesn't have access to. So that would be a problem. But you could have every member of a public body attending virtually from their own house or their own office, and a physical location that just has a staff member and a big video screen. And that's permissible so long as you take public comment from that physical location and the public body, or the public is able to see, everyone on screen is able to see the same thing that the public body members see. So it's important to keep an eye and really try and make sure that again, you have that public access. A note to the chat functions. I often recommend that they be disabled if possible. And if this is chat functions on Zoom, on other meeting software, whether the meeting's entirely virtual or partially virtual with physical component. The chat function would not per se violate the OML, but it poses a lot of problems in ways that it could. If you can disable it, great. If you can't, the request is that it be limited to communicating with staff regarding technical difficulties or other things that aren't really part of the meeting. Because if you have members commenting in the chat function, those comments are part of the meeting. And they then will need to be recorded in some way, as well as the public needs to be able to see them and read them. And usually the chat function is not on display when you have a broadcast in that room or other things. So again, we usually just say, if you can request that your public body members not use the chat. If they need to say something, say it out loud, then it's part of the audio recording of the meeting and public can hear it in the same. So before I get into OML violations, I know I just covered a whole lot. Do we have any questions here in Vegas? Yes.
Does the public or does a board member who's appearing by Zoom, should their camera be on then? Is that?
There is no legal requirement. We've gotten this question before. There is no legal requirement that the camera be on, because you could hold a meeting that was entirely telephonic, right? You might have somebody attending via telephone. You do need something the minutes of your meeting need to include who was present. So if there's a way you can verify that the board member is present. When it comes to contested cases, I would be even more concerned to make sure that you have, and maybe that's just doing a roll call after every recess and making sure that they're present and available. When it comes to voting, you can record, you're recording votes. But the law doesn't contain any requirement with respect to cameras. Yes.
Questions if there's time. So I help with the board in our division, and we have on the agenda, we have public comments set for the beginning of the meeting and the end of the meeting. And then between that, the board votes on several items. If a member of the public wanted to comment again before a vote, does the board have to stop to let them, or can they just proceed?
So long as they've offered, sorry, the question, I don't know if you can hear up north, but the question said, so the question was if there's public comment at the beginning and the end of the meeting, but a member of the public wants to comment on an item during the meeting, whether that needs to be permitted. The answer would be is so long as you've given those 2 periods and the one in the beginning, they're allowed to comment on any item on the agenda. They're not required to take additional because they had an opportunity to speak prior to the item being heard. So you don't have to, you can, though the recommendation is if you did allow a member of the public to speak, then you can't maybe limit it to just that one member because there might be others that want to then express an opposing viewpoint and you need to allow that. But if you've offered them the opportunity at the beginning of the meeting to speak on any action item or any item in general, prior to, that's the main goal of this, is that public bodies are ensuring that the public has an opportunity to be heard prior to the public body considering and acting, basically acting, so they can.
Does that be a question with
supporting materials for this one board, it will be thousands upon thousands of pages. So they put it online. If a member of the public showed up in person and requested the materials at the time of meeting, does the meeting have to be stopped to get them those? Or was it reasonable to say you didn't request these ahead of time and they're online?
So you need to have, and so this was a question regarding supporting material. There needs to be one copy of the supporting material available at the physical location, just one. And if a member of the public shows up at the meeting and makes a request for their own copy, you do not have to stop and give it to them. You can say you get to view the version that everybody has. We did have one request. I think we had one complaint, and I think this one we determined was not a violation, that where it was incredibly voluminous. Instead of it being a printed physical copy, there was a computer or a laptop or other at the physical location available for public to view documents. But it needs to be something so that the public is able to view those documents at the meeting, but you only need that one copy at the meeting. If they then make a request and say, I would like a copy. We've also had this on a complaint where the individual who was responsible on the agenda for providing supporting material was also had duties during the meeting, assisting and running to the meeting. This was a staff member. And so they were not able to comply with this request for documents that they received right at the start of the meeting until it was either the next day or shortly or some hours after the meeting. And we found no violation there either, because it's a reasonableness in terms of how quickly the public can. Usually when it comes to supporting material requests after the meeting, those we say can be treated as public records requests and follow the timelines and everything on a under the public records law. The requests before a meeting, you need to have those usually available a little bit quicker. But again, if it's during the meeting, you just need to have at least one copy available to the public.
In the South and North, we'll need the copies available in both locations.
Whatever's your primary location, it depends a little how it's agendized, but if you can agendize one as a primary location, since you're only required to, many bodies will say, this is the location of the meeting, wherever that be, whether that be in Vegas, whether that be in Carson City, or wherever in the state, right? This is a primary location. Then the list of video conference location. Obviously, I'd recommend having additional copy, a copy available in each place, because you might have public attending. But if you have one location that's really designated as this is the location of the meeting, that's where you have to have it. And the other stuff is extra. And the main reason our office has interpreted a lot of those requirements is if we were to say, when you do extra, like having extra locations, you violated because you screwed up some little part of it, public bodies aren't going to offer the extra locations. So with an eye on the most public access possible, but the violations are if you don't meet the minimum requirements. Yes.
If you have had a closed session, it's kind of a two-part question. Is it correct then that the minutes that you make for that closed session would be separate from the larger group of minutes that you made for the whole thing?
Correct.
Okay.
So the minutes, both the recording and the minutes are separate. If you look into the minutes portion, the statute's 241.035, and I don't know the language off the top of my head as precisely, but it does have provisions regarding when those might become public again. If you were holding closed session to discuss the character of an individual, they are permitted to get a copy of the minutes and the recording, but it's not generally a public record available to everybody else unless they request it to, and there's some provisions about when it becomes public later.
The second part of the question is, when you go to your next meeting to approve the minutes, would you then take those separate closed meeting minutes and only put them in the private book and not in the public book?
Correct. Yeah. So the supporting material requirement is that supporting material has to, anything that meets definition of supporting material has to be available to the public unless it's confidential by law. And there's a couple other provisions of things that aren't, but this would then be confidential by law because there's a later statute saying that those minutes are, and anything that's confidential by law for a lot of licensing boards, that might include background checks for licensees, that type of information can go in a private board book that only board members get. It is supporting material under the definition, but it is not required to be provided to the public. Do we have, yes.
Sorry, Leslie, really quick. So if our current, recording software does not allow us to manipulate the recording at all, right? And so if we get a public records request, hopefully this isn't covered in the next section, but if we get a public records request for the video of the meeting, I will typically give them the audio, because our audio recording, we can actually parse out the closed session. So is that considered a violation? I don't want to tell myself, but could that be considered a violation? Because I can't provide you video because I can't.
So the requirement under the OML is that it be at least audio recorded. So because you can provide audio, you will have complied with the OML, and I will leave the rest of the question to the public records presentation that is after this. With respect to the video being, with respect to what to do when you have a video that is public record, but a portion of it is not, and technical issues with redacting. Do we have any other questions in Las Vegas? Do we have any questions in Carson? Okay, not hearing any. I'll get into what happens if there's an OML violation. In general, actions taken in violation of the OML are void. Our office has the authority to investigate and prosecute violations upon the receipt of a complaint alleging a violation of the OML. However, if you know that there may have been a violation of the OML in a meeting, if you correct it during the same meeting, then you've cured that violation. I mean, if it's correctable, an example might be you discussed an item and voted, and then you realized that the audio that you had of the item perhaps that was muted and the public didn't hear what happened. But during the meeting, you go back and say, okay, let's re-talk about everything we just did. You redo the item where the public can hear. You've just cured it. That's okay. Corrective action is recommended. If you take corrective action within 30 days in a new meeting and say, you need to list the item as for possible corrective action. And especially if this is something, for example, public didn't have access, you learn later that the agenda was posted wrong and there was action taken at a meeting, but public didn't have notice. You need to redo the meeting. And that doesn't mean rubber stamp everything you did. You actually have to have a new deliberative process, take public comment, list the items as for possible corrective action. However, if you do that within 30 days, our office will usually, that will usually cure it, and we'll look at it and say that we're not going to proceed with any prosecution of violations. Note that any corrective action is prospective only, so you can't relate back to when the void action was taken. The new action that you've done correctly, you can rely on and say, we took that action right, we're going to move forward. But if you took an action in violation of the OML, that one was void, and simply redoing it later doesn't relate back in time. Our office, when we get, just generally our process, I'll go real quick, but if we get a complaint that states a claim under the law, we will go to the public body for a response. We will perform additional investigation as needed so that we can determine what occurred. If it's an allegation of something occurring during a meeting, usually the recording of the meeting will solve most of that, but sometimes there's allegations of serial communications or things occurring outside of meetings that might require us to interview members and do further action. We then will issue an opinion that is either a no violation letter or a findings of fact and conclusions of law. And in circumstances where there was an action taken that was clearly void, we have the ability to go to court to have an action declared void. There's also private action, private right of action if your rights were violated, to go file to have something declared void. It has a very short statute of limitations, though it is only 60 days. And lastly, updates from the 2025 session. I kind of mentioned those as I hit them going through, but the attorney-client exception is no longer limited to advice regarding potential or existing litigation. It is limited to legal advice, though. The physical location requirements for meetings to adjudicate contested cases or consider regulations, it's clarified into which meetings those apply to. So there was some clarifications added. That simply means you cannot hold an entirely virtual meeting to adjudicate a contested case or hold a regulation hearing is where that clarification went. Regulation hearings, workshops, and the major steps required by 233B for regulations. I mentioned the phone number reading during first public comment. If you have a physical location, you do not need to read it. And there was also a clarification in the law that the OML does not provide protection for defamation during public comment. The change in the law here really doesn't put any duties on public bodies or their members when it comes to conducting meetings. What it simply does is say that if somebody gets up during public comment and defames a staff member, defames another person, that person who was defamed has the same rights to file a defamation action in court that they would if that person made that defamation on a street corner. So it just kind of defers to case law on that. The public body is not in a position, nor is our office, of enforcing defamation. And all of these updates can be found in AB 64 from the 2025 session. So I'll take any last questions. I also note some links here you can find on our website, our OML manual, as well as training on the OML. All the trainings from today will replace existing videos on our website. We try and keep an up-to-date training on the open meeting law. And while I take questions, though, I will put the QR code for CLE credit. Yes.
So we have student complaints, and sometimes a student will throw another student by name under the bus, and but we have FERPA that we have to deal with. So what do we do when they accuse or say something was provided? Like in this one case that I went back and looked at, it talked about FERPA and HIPAA because it was about something medical that they allowed the student to do. How do we handle that? And then do we publish that person's name?
I mean, that gets into more detail where I'd probably say consult with your body's legal counsel on the specifics of it. In general, like I said, with where you have a law like HIPAA or, FERPA obligations to keep certain information confidential, you can, under the supporting material requirements, you can keep things confidential. It can be a little bit more difficult, and we've encountered a few of these issues when it comes to names, because if you are going to take administrative action regarding a person, their name has to be on an agenda. And so it can be difficult when you're not wanting to include the name. It's an area that potential OML changes could be helpful for. For some of the bodies that have worked through this, some of what they've done is delegate authority to a staff member or to a single public body member to say you have the authority to take certain actions regarding this, which allows the names not to have to go, which means the public body as a whole. I didn't address delegations a lot in here. I meant to under the attorney-client as well. Public bodies, there is a lot of authority that they can delegate if they want. It has to be delegated specifically, whether it's to a staff member or to an individual member. If they delegate to multiple members, they may be creating a subcommittee, which can cause the same publicity, public issues. But the delegation itself, what's important to note is the delegation itself needs to be done during a public meeting. And I recommend that bodies have some policies and procedures or bylaws as a location to put any delegations, because there are many bodies that may make a delegation. And while, yes, it's recorded in their minutes, years later, people don't know where to find them or whether it was actually done, and finding those minutes can be difficult. So again, a big recommendation of mine is having bylaws or policies and procedures that any delegations are kept in. But they occur during, so the delegation can be part of the job description of a staff member, that they have certain duties, and by passing that job description during a public meeting, they are delegating those duties to this staff member and the power to do that. Do we have any other questions? I think I'm out of time. So I will close out of this and turn things over to Leslie Nino-Piero for public records.